All right, well, welcome back. And I'm super excited to be up here with you guys today. And since our theme this year is momentum, I wanted just to give you a single definition of momentum. It's the strength or force that allows something to continue to grow stronger or faster as time passes. Catherine Foster, the president and CEO of Americans United for Life, and Tom Shakely, executive director from Terry Schiavo Life and Hope Network, are here today. They fill this definition extremely well. If you don't believe me, read their full bios in your program that you have in your bag. They keep the momentum going within this movement, and they keep the momentum going for life. You should really look up to these people, and you should be really excited for them to come up here today. So as they can keep this momentum going, let's welcome them up here with a warm welcome.
Are we sitting?
We consider stand. It's up to you.
Okay. I feel a little bit weird sitting here, actually. Maybe we can re-sit for Q&A.
Okay.
Okay. We could have planned this out in advance.
I'll stay here.
Didn't totally. So I'm Catherine Glenn Foster. I am absolutely delighted to be able to join all of you here today. This is, I have to say, maybe my favorite event of the year because it is so encouraging to me personally to be able to share a room with so many young people, with the next generation, with people who are coming up. In many cases, you've spent your entire lives, since birth, since childhood, caring deeply about this issue, and a lot of you too have converted. Maybe you found out more. Maybe you heard more from parents or teachers or friends. But it is just such a pleasure and an honor to be here. I am president and CEO of Americans United for Life. We work in the legislatures, the court, and the culture to ensure that everyone is welcomed in life and protected in law from conception to natural death. And it's that natural death piece that we're here to talk about here over the next hour or so. We're going to start with a few definitions, just to draw a common thread, but to show that that they are different in the law and, in fact, in practice with what we're seeing playing out in the culture here today. Even though there's this common thread of respect and dignity at the end of life, we work in the law, so we do see that there are differences in the law between these things, but there's this common thread. There's a right to refuse medical treatment, and that's not what we're really talking about. The Supreme Court has said that the American Medical Association has repeatedly emphasized the, quote, fundamental difference between refusing life-sustaining treatment and demanding a life-ending treatment. And that's not really the topic. We are going to be talking about denial of care. And in our culture here today, that can even include food and water. That can include basic needs that all of us have, and maybe someone just can't, pick up a spoon and eat in the way that you or I might be able to, but that can be included in this. We're talking about basic standard medical care and the denial of that care, which in many cases leads to euthanasia. And that is intentionally and directly acting to cause the death of another person. You may think lethal injection, and that's one of the ways, but there are a number of other ways as well. And then finally, physician-assisted suicide, and that is, again, intentionally and directly providing the means of death to another person so that that person can use it to commit suicide, like giving them the drugs to take. And again, there's this common thread. You don't see a whole lot of difference in practice at times, and in fact, of the 5 bills that came before the Hawaii legislature in the last session, at least one would have just outright allowed for euthanasia, but in the law, we do see that there are differences. And first, let's talk about that denial of care, more euthanasia kind of issue. Medically vulnerable people. Who does that affect? We're usually talking about elder adults, people who may be ill, may have an injury, maybe they were in an accident, like a car accident. And what we have to remember is that patients deserve a chance to recover. People deserve a chance to recover, but that doesn't always happen. Now, a lot of times it's because these individuals are diagnosed with one of a few different conditions. A lot of diagnoses of, for example, brain death. Now, that's really a contentious diagnosis. It's a much longer talk than we have time for here today, but people will say, oh, you have brain death, or persistent vegetative state. A lot of times a longer-term illness like cancer, or another illness or condition where you may think that the patient may die without life-sustaining treatment, plus a medical determination that the patient has no chance of recovery or improvement. And when doctors start to go in that direction, then you start to see that, that they may be pushing for removal of care. And it varies by state. There are a number of different legal standards out there. I'm a lawyer, so this is what I find especially interesting. But there are a lot of different legal standards. The three main ones that we see, from most to least protective, are the subjective standard. That requires a really clear expression of intent by the person, that the person said, if I were in this situation, here's what I would want. So it would not be enough to meet that standard if the person said, oh, I wouldn't want to lose my dignity before I died. Because then you say, well, you know, what does that even mean? That a person wouldn't want to be a burden on their family. You know, you may have heard that before. I know I have, even in my own family. That is not enough for the standard, or that the person wouldn't want to live that way. Now, the most common standard is substituted judgment. You basically use you figure out what the patient would have wanted if that person were competent. If they were legally competent to make the decision, what would that person have done? And so you look at their wishes, you look at other factors. It doesn't require a specific statement, so it could include things like an inference, like, oh, I wouldn't want to live that way, I don't want to be a burden, that kind of thing. And then the third main standard that you see is the best interest standard. And that's the most dangerous of all. That's where someone from the outside is coming in and saying, well, it's in your best interest not to live. It's better for you to die than be in that condition that you're in. And it's extremely, extremely dangerous. The wishes of the patient aren't even necessarily dispositive in that case. The patient can have said, I want to live. This is what I want. I want to be given every chance at life. And that wouldn't necessarily be enough. Now, there are a number of Supreme Court cases and lower court cases that have led to this point. The Karen Ann Quinlan case was one of them, one of the first ones. She was a 21-year-old diagnosed with persistent vegetative state back in 1975. She had been at a party. I guess things had gotten a little bit crazy, and she ended up in the hospital. The doctor said that she had no hope of consciousness, and her father wanted to stop the ventilator. Doctors said no. Doctors were trying to preserve her life, give her every chance to improve. Her father petitioned for guardianship, and the New Jersey Supreme Court said that there was a right to withdrawal of treatment, substituted judgment standard, based on the constitutional right to privacy. We've heard that before. So Quinlan and subsequent courts based their decisions on cases that held that there was a right to privacy, encompassing such personal matters as contraception and abortion. And they said that that right to privacy included whether she could, or someone on her behalf, could choose to refuse life-sustaining treatment, and they could withdraw the ventilator. So they did. And she, in fact, continued to live for 10 more years. She died of pneumonia in 1985. So you see that maybe it wasn't right. The next major case in this area, the Nancy Cruzan case, she was in Iraq, 26 years old, tragic case. Her parents wanted to remove the feeding tube. And in 1990, the Supreme Court ruled that competent patients have a constitutionally protected liberty interest in refusing unwanted medical treatment, including hydration and nutrition, the basic food and water that all of us need. They did say that the liberty interest has to be balanced against the interest of the state in preserving life, and that states can establish procedural safeguards and can require life-sustaining interventions, but still extremely, extremely dangerous. And then I think we're all familiar with the case of Terry Schindler-Shivo, and my colleague Tom will be discussing that a little bit later. But those are some of the primary cases in this area. Whatever the situation, when you run across a case like this, you usually don't have long. I have worked on this issue for about a decade, and so often a family will call and say, you know, my son, my daughter, my sister, brother, mom, dad, grandmother, niece, whoever it may be, she hasn't had food or water for 6 days, 8 days, 10 days. And so all of a sudden you are, I mean, it's just this, you know, emergency situation where you have to jump in and do everything that you can. And, you know, you're looking for local counsel and just trying to talk with the hospital. Did you get a second opinion? Have you talked about a transfer? What's the ethics committee saying? Did they provide you with all of the proper forms? And in many cases, the answer is no. And in fact, my first end-of-life case was one of those kind of emergency situations. It was a bit different, but I was a new lawyer, and I was told to just jump in and do what I could. And so it was a case about 30 minutes north of my home. I go up, I show up in the courtroom, and it seemed strange. It was my first time in the courtroom as an actual admitted attorney, and I'm thinking, this seems not like courtrooms are supposed to go. And there was some whispering, and we found out that in the midst of these motions, in the midst of local counsel doing everything that he could to save a gentleman's life, that his wife had been fighting back, and the gentleman had died that morning. And I was sitting there in the courtroom, and I looked over, and I was just looking at her face, and she was, laughing, smiling, hugging her attorneys, just almost jubilant. We found out later that there was a significant financial settlement involved. You know, it's one of those things where you drop everything and do what you can to try to save a life. And it doesn't always work, but when you do, it is, it's like nothing else. I mean, they're just, when you meet the people whose lives you saved, when you talk to their relatives and hear about how they're doing, it's just, it's heartwarming. But it doesn't always happen because families don't always understand the implications of what's happening. They trust the hospital, they don't understand the level of involvement they're entitled to and can claim, and then when they realize there's a problem, a lot of times they don't know where to go. And the core issue is who's going to decide. Is it going to be the patient? Is it going to be a family member? And is that family member going to have the patient's best interests at heart? Is it going to be a family member who maybe doesn't? Maybe an estranged spouse. We've seen case after case of that. Is it going to be the hospital or the facility? And that's concerning. You know, when you're figuring out who could best speak to what the patient would want if the patient could speak for themselves. There's some baseline care that everyone should get, but then there are other things that you think, well, what would the patient want there? And as a side note, just really quickly, a lot of times patients even act against their own best interests, thinking that they're doing the right thing, but they'll, you know, come in with some kind of written directive. And I've seen case after case where that can be incredibly dangerous because when you have your wishes spelled out in writing, it seems like it's a safeguard, but really you're limiting. You're creating a document, a written document, often legally enforceable, that can have loopholes. A document where the doctor can say, well, you know, she said that she wanted care in XYZ situations, but what about the G situation? What about that? And then they find a way around it. And there was even a situation where there was a gentleman who had a great, what appeared to be an airtight advance directive, and he was sitting up in bed asking for food and water. And but the doctor had said, no, you have persistent vegetative state. And you're thinking, well, that can't be right. This person is communicating, they're talking, they're asking for food and water. And instead the doctor said, no, we're going to cut it off. And they did. And the family was trying to fight back. That doctor was brought before an ethics committee, but his excuse was that PVS is a spectrum diagnosis, and he believed that this gentleman was legitimately within the spectrum. And so we see that. You know, we're working to restore the patient's voice. There are a couple different situations where this can arise. It can be an intra-family conflict, whether it's continued care, whether treatment is futile. And we see a lot of these, a lot of situations where maybe there's siblings who disagree, different family members who disagree. A lot of times it'll be estranged spouse versus parents, things like that. And it's a tough situation. We had one situation, this gentleman, Jesse Ramirez was his name. On May 30th, 2007, Jesse Ramirez, he suffered severe life-threatening injuries from a one-vehicle accident, in part because he was in the middle of a fight in the car with his wife, Rebecca. And they had a marital history of separation, infidelity, domestic violence. At one point, she said she was going to leave him when the children turned 18. Not perhaps what one might call an ideal marriage. She stood to receive all of his property, all of his benefits if he died, and was the medical surrogate. So he was being treated, was not on life support. He retained brain function. He retained some kind of awareness of his environment. We're talking about just a few days in, not even a full week had passed. So we're in a situation where there's no way doctors should be making, or family members should be making, any kind of permanent kind of decision. We're just way too early for that. He was clearly responding to touch, and he seemed to be improving even. But the neurosurgeon said that there was a chance that he could pull through, even talk again, but Rebecca was given 3 options. And she decided to transfer him to hospice 10 days after the accident, where he was denied food, water, and antibiotics. She was given 3 treatment plans, 2 being continued treatment, 1 was hospice, and her response was, this is a quote, "How fast can you move him? Can it be today?" When his parents tried to visit, this is a quote again, she said, "You have to leave." She said, "This is not a freaking sideshow." Horrible, horrible situation. Family went to court to save his life, and they won. The feeding tubes were reconnected, and less than 5 months later, he walked out of the hospital. He is still living, thriving, doing an amazing job. Now, a lot of times when you have a conflict within the family, the hospital can get involved too. If you have any kind of disagreement at the hospital will kind of hear that. They'll, depending on what their interest is, sometimes they'll kind of inject themselves. They'll start expressing their opinions and start using advanced directives or perceived cracks in the unified family front, whether it's because of money or organs or whatever. There was one recent case, there was a 22-year-old, he was shot, and doctors declared him brain dead. Now, this young gentleman's driver's license said he was an organ donor, and they wanted to start the process of using his organs. His mother believed that he was responsive, his father didn't, so one of those intra-family conflicts. The mother requested a second opinion, the hospital said no. And then we found out that the hospital had done only really minimal testing, not even an EEG. The hospital had scheduled organ harvesting for 6 a.m. the next morning, but working with local council, we were able to get through to hospital general counsel, and it's this everyone, who do you know? But the hospital general counsel said, got to conduct the EEG, postponed the organ harvesting, and was able to just get involved and buy the time to at least figure out, is this the right thing to do? Does this person have a chance? Give them the possibility of recovery. Give them a chance to recover. Now, a lot of times also you see, I'm going to have to really hurry here. I'm sorry. I get really into the stories. I love telling people about all the amazing stories of people who've been in danger and who so often have pulled through and recovered. So, you think the hospital, if there's a bed full, that they're getting paid and everything's going to be great for the hospital, right? And that's not really true, because when you look at what the hospital bills, what private insurance pays, and what Medicaid or Medicare pay, you see that they're completely different. And so when a hospital is caring for someone, depending on their insurance, the hospital could be losing money. And this is something that they track. The longer a Medicare or Medicaid patient stays, the less likely a hospital is to get its bill paid. When you have a traditional beneficiary, there's a deductible. Once that's met, you have to pay per day. If you're on a fixed income, then it can be easily more than you're getting. So the hospital is seeing an unpaid bill. 150 days in, that's the max. That's the limit for your lifetime. And the hospital is really seeing an unpaid bill, and you're in an uninsured situation, and the hospital can transfer you. And that's a problem because, if they don't have a place to transfer you, then they're figuring, what can we do? And the hospital knows about this, of course. They have their council, they have their ethics committees, and they keep an aging report. They even have reports on how to maximize patient turnover and decrease long-term residence in this aging report. The reports recommend that aging reports be run at least monthly, both in summary and in detail by patient class. Are you private insured? Are you whatever? And then if you're private insured, then not a big deal. But if you're not, then that's a problem for them. And their recommended goal is to have a population of less than 20% of the total accounts receivable, 120 days or older. People have called this the most valuable accounts receivable analysis instrument. So that's a danger from the hospital. We see futility of care statutes, a huge danger. There was one study of policies at 26 California hospitals, and they found that all but 2 defined circumstances in which life-preserving treatments should be considered not important, non-obligatory, even if they're requested by a patient representative or even by a patient. And the authors said that healthcare providers have a right to refuse to provide that treatment, and then they can defend their decisions as just being consistent with professional standards. There are not a lot of cases where you see patient-hospital conflict. I think Tom may discuss the Jahi McMath case. There was one where a hospital was removing food and water from a fully responsive woman with an infection who had near a medical stent, and they said that she had lived her life and the family should let her go. And there was one where a doctor said that the living will requesting treatment didn't matter. We've seen hospitals ignore clear requests and just pressure the family to make a decision soon. Now, there are federal and state protections that you can use, but you have to know how to use them, what they are, how to use them, and a lot of times you need help to do that, whether it's a patient advocate, whether it's counsel, whatever it may be. Just a couple of quick steps. Ask for a second opinion, start looking for another hospital, and reach out for help. And there are organizations out there that will help you, legal groups, Tom's group, so many wonderful organizations that can come alongside and help. Taking just a few minutes to talk about the assisted suicide end of this. Also a huge threat. Both of these are huge threats in our nation today and really increasing. So when it comes to assisted suicide, first of all, we have public policies against suicide. We have laws, we have regulations, we have guidance, we have resources to discourage suicide. States have recognized suicide is bad. States have recognized significant medical and non-medical costs and the physical, emotional, and psychological damage to patients' families and friends. This is true across the board, even when the person is facing a terminal illness. We think about the case of Robin Williams, and how tragic that was, and you compare the media response and the public response to his death as compared to people who were, for example, advocating for assisted suicide. But Robin Williams' son has spoken out about the heartbreak he experienced in losing his dad, and it's just tragic. If this is true, even when the patient is looking down that long, dark tunnel of depression. But when you take away, the gun or the whatever the means is, and you replace it with a prescription for pills, for poison, some people start to feel differently, even if it's the same diagnosis, even if it's the same prognosis. When you have that medical cachet saying, well, that's okay, you can do this because we have a doctor coming alongside you. Then some people start to think it's okay. And an Irish colleague, Kevin Fitzpatrick, he told this illustrative story. He was a paraplegic, died a couple of years ago of cancer. What he said was, when non-disabled people say they despair of their future, suicide prevention is the default service we must provide. Disabled people, by contrast, feel the seductive, easy arm of the few supposedly trusted medical professionals around their shoulder. Someone who says, well, you've done enough, no one could blame you. And in essence, The point of assisted suicide is to license professionals who are given the power to decide, you qualify, you don't. Where is it legal? So physician-assisted suicide and euthanasia have long been rejected worldwide, with just a few exceptions. Switzerland was the first to legalize in 1940 and is the destination for what people sometimes call suicide tourism. The next major changes in the law weren't until the mid-1990s. Australia briefly legalized suicide in its Northern Territory, and then it quickly became the first and only place to repeal it. Colombia was exploring it there, but it didn't have regulations. It just a court ruled that euthanasia on request was legal. They didn't pass a law on the matter. The mid-1990s was in the midst of the Jack Kevorkian scandal. A lot of states started passing laws saying, no, you can't have assisted suicide. Then through the 2000s, there was another big push. The Netherlands, Belgium, Luxembourg all legalized euthanasia and or assisted suicide. Still, we're talking about only 4 of 50 European countries, so not that many. In the last couple of years, we have seen Canada, a big push in Australia. We've seen lawsuits in New Zealand, lawsuits in South Africa, all around the world. It's a push. It's a threat. In the U.S., we have Washington, Oregon, California, Colorado, Vermont, and D.C., which is the first majority-minority community to legalize assisted suicide. And working with minority communities here in our nation's capital on this issue, I can say that, that the people I worked with had such concern about this. This is not something that an overwhelming majority of the people that I was talking with were interested in. But assisted suicide has failed around the world. In the U.S. alone, close to 200 times in well over half the states. And from those 20 years of effort that we've seen since Oregon, only a handful of states have been willing to risk it. It has failed in Australia, France, New Zealand, Scotland, and the European Court of Human Rights. And the Supreme Court, our Supreme Court, has said that for over 700 years, the Anglo-American common law tradition has punished or otherwise disapproved of both suicide and prescribed suicide. There's no right in the U.S. Constitution, there's no federal law on the subject, and the Supreme Court has said that a ban on assisted suicide furthers compelling state interests like the preservation of human life and protection from medical malpractice, coercion, financial pressure, and psychological complications. The Supreme Court worries about a slippery slope. They said if we legalize assisted suicide, we could start down the road towards voluntary, even involuntary euthanasia. And most of the U.S. states have a specific statute prohibiting it. Many of them passed in the mid-1990s as a specific response to Jack Kevorkian. Now, you see in the courts that assisted suicide activists are trying to say, well, that was never meant to apply to doctors. That applies to just ordinary citizens who, want to do something to, with their father. No, it was in so many cases passed specifically to address the problem of doctors. And that's reflected in the legislative histories, and that's why a strong legislative record is so important. And it's been the basis for winning cases that we've seen in California, New Mexico, New York, Tennessee, New Zealand, all of these different places where we've won lawsuits and said, no, there's no right to assisted suicide. We don't have time to go through all the reasons why it's bad public policy. I'd love to do it if people want to bring it up in Q&A, but people are concerned about pressure to die, the risk of inaccurate diagnoses, a reduction in end-of-life options, the expansion of it, sloppy procedures. People are worried that the focus will be on saving money, not on saving lives. And studies have shown that for most people who do pursue assisted suicide, it's not pain, it's not about fear of pain. A bioethicist, Ezekiel Emanuel, he summarized that the reason is typically depression, hopelessness, and fear of loss of autonomy and control. And he said, in this light, assisted suicide looks less like a good death in the face of unremitting pain and more like plain old suicide. There is study after study to back this up, problems with depression, that depression is being overlooked as one of the factors. But the bills we've seen don't have a screening requirement or any kind of counseling requirement, I should say. 94% of doctors have said that they aren't competent to determine if a patient needs counseling in that one required visit. And they just don't feel like they can make that decision. There's misdiagnosis issues. 15% of total diagnoses incorrect, 40% for disorders of consciousness, 50% for persistent vegetative state. That hasn't changed even with medical advances over the last 15 years. 17+% of prognoses are wrong, and that's backed up by stories from the field. There's economic duress from insurance from family members. The process itself is not as pleasant as it's made out to be. You have to choke down this bitter drink. It usually takes 3 to 48 hours to kill. Vomiting is common. Some patients have regained consciousness after taking this drug, and 1 in 5 don't die from the drugs at all. Assisted suicide raises standard suicide rates. Study after study has shown that. It's called suicide contagion, or the Werther effect. There is a significant increase, at least 6.3%, and when you look at an elder adult population, it goes up at least 14%. So you have that risk. You have the risk of elder abuse, of disability community abuse. You have significant slippery slope concerns. In Belgium, half the people are being euthanized without request. You see it expand to children, to people without a terminal diagnosis, on and on and on. And you just see this slippery slope. You see this shift happening, and it's terrible. You see that in practice, and you see real lives ending, real people dying. Physicians are worried, conscience rights issues, pharmacists, other healthcare professionals, coroners are worried. There was the head of the California Coroners Association wrote a letter saying, what do we do with this when California legalized assisted suicide? It was an open letter. It was published in the paper, and coroners don't know what to do. There are inadequacies in the law, in pretty much every law that we've seen, but really no safeguard is enough. Australian Paul Russell wrote, "I have never come across a safeguard that could guarantee safety for vulnerable people. After all," he said, "unless we describe in the law every possible illness and every possible remedy, what possibility is there that we can ensure safety? The variables are infinite. What the supposed safeguards do well is protect doctors. They are provided with an immunity from prosecution for homicide or assisting in the suicide if they comply with a set of procedures, and yet we see this push. It's continuing, it's out there, we have to fight back against it, and we can win." We saw 3 years in a row a bill brought in Connecticut, a strong pushback using media, using social media, using every technique available out there. We can talk about that later. Happy to help if anyone's facing this or just any kind of legislative issue. But it was so successful that even though they spent $500,000, the head spokesperson for Compassion and Choices said that if that bill had come to a vote, that it would have set the movement in Connecticut back by years. And we have hope. There are choices that we can live with. So when it comes to denial of care, euthanasia, assisted suicide, we have options and we have hope. And I'll turn it over to Tom, and look forward to hearing about what you have to say. Thank you all.
Thank you very much, Catherine. Thank you, Catherine. Am I good here? Okay. Thank you very much, Catherine. So you've heard a whole host of sort of the legal and historical basis for this fight on assisted suicide, and the fact that assisted suicide is just one part of one of the sort of poison fruits from a whole tree of confusion and lies about essentially human dignity. This is what ties these issues together, is an understanding of what is the human person and what is the human person for. Now, Catherine's given you a great perspective on particular aspects of the fight on assisted suicide, but also on the euthanasia issue writ large. The group that I work with, the Terri Schiavo Life and Hope Network, is named in honor of Terri Schiavo, who died in 2005, and she was a victim, prominently, she was a disabled woman who was a victim of what we can just call involuntary euthanasia. So in 1990, Terri was a healthy 26-year-old young woman, recently married, and she collapsed, and we're not quite sure, there's still no sense of what exactly caused the collapse, but she suffered a serious brain injury as a result. And so over the course of the years after her brain injury, her husband, naturally Michael, became her guardian, her caretaker. But within a few years, it seemed that Michael kind of lost interest in caring for Terry and shifted from a rehabilitative mindset to a sort of a warehousing mindset where Terry was kind of left by herself, not given any kind of rehabilitation, despite early promise of that. And ultimately, Michael, of course, pursued a very public path that came into conflict with Terry's parents, her birth family, Bobby Schindler, her brother, who I work with at the Terri Schiavo Life and Hope Network, because Michael's goal was to end Terry's life. And so frequently you'll hear Terri Schiavo and cases like hers today described as end-of-life cases. But the fascinating thing to keep in mind about that is that Terry wasn't dying. She was a disabled woman, but she wasn't dying of any disease. She didn't have a terminal illness. She had a disability. Her story only became an end-of-life story when a loved one, in this case her husband, someone who should be the closest person in the world to her, decided to actively try to end her life. That's when it became an end-of-life issue. And in most cases on the assisted suicide issue, it's a similar idea, right? It's once you choose to no longer live, or once you choose that somebody else should no longer live, they become seen as an end-of-life issue, as if there's nothing else that can be done. When love is always the proper response, right? That's the response that puts things back into perspective from that human dignity mindset of who are we? You know, are we valuable because of the things that we can do? Are we valuable because of the skills or talents we have? Because one person's very smart, or one person's very capable, or one person's an excellent athlete? Or are they valuable, each of these people, because they're human beings, and that we share in this universal sense of human dignity? So these issues are all related on this whole spectrum of life, from abortion to euthanasia. And that's the thing that is worth remembering about Terry and people like her who were not reliant upon life support. They were not on machines in any traditional sense. Terry just needed food and water, like so many people do. So this is a real important thing to remember about human dignity. Thomas Reynolds wrote a great book a few years ago about his life with his disabled son. And he used a phrase that I want to share here because I think it speaks to the reality of this human dignity issue on assisted suicide, which is that there aren't one group of people who are abled and one group of people who are disabled. You know, the common thread that unites us all is the characteristic of what Reynolds calls vulnerable personhood. Because whatever particular circumstance we find ourselves in right now, whether we're young and healthy, or whether we're older and less healthy, or wherever on that spectrum, we're all vulnerable. We're vulnerable people who are here for a limited time and will pass on. But the trick is to remember what we are as people. And so assisted suicide is just one particular fight we're having about human dignity and about euthanasia writ large. Should we have euthanasia permitted broadly and very liberally, where you can actively choose euthanasia, or where you can have it imposed upon you? Or do we want to be a society, as Catherine talked about, that has legal protections for people and that recognizes that the assisted suicide debate really should be the easiest debate to win, whether that's in conversation with somebody who maybe favors it or just has questions and wants to talk about it honestly, or whether you're talking about a legal and legislative fight in a state house or on the national level. If you take the phrase assisted suicide and you remove the word assisted, it becomes very clear instantly what this is really about. So for somebody who's maybe in favor of it, and they say, well, people should be able to do what they want with their own bodies, so I'm in favor of assisted suicide, remove the phrase assisted and say, should people still be able to do what they want with their own bodies with just suicide? And the answer, almost every time is going to be universally no, of course not, because that's a tragedy. And so merely including assistance, in other words, forcing physicians and medical staff to enable a suicide, actually be enablers in this, is not good. But to remember that the people who are considering these things may not even be at the end of their life, right? In the same way that Terry was not an end-of-life issue until someone wanted to end her life and went to court to fight for that, perversely. The idea of folks who might be considering assisted suicide and they say, well, maybe they have a terminal condition. Increasingly, the phrase terminal is being changed, it's being manipulated, it's being altered in our society, so that if you merely have a chronic condition, literally say that you're diabetic, there's a push to say, well, perhaps it's a bit of a stretch, but perhaps you should be considered a candidate for assisted suicide in some places because you have this chronic condition. You're never going to not have diabetes, and it's this thing that's impinging upon what they say is your quality of life. So perhaps we can describe you as facing a terminal condition in some sense, and you can be a candidate for this. So the word even terminal, these things that we think should be very clear-cut, terminal maybe means somebody in the very active end stages of life, can now mean somebody who's 30-something years old and just has a chronic condition that they don't want to deal with anymore. Which brings us kind of back to the 30,000-foot view of all this, which is, why would somebody either want to end someone's life, a loved one in their life, or why would they perhaps themselves contemplate something like assisted suicide? And in the vast majority of cases, it's due to a failure of love, and it's due to a failure of relationality. That idea that Tom Reynolds talks about, of vulnerable personhood. People who have others in their life that really love them don't want bad things for that person. Archbishop Chaput in Philadelphia has commented on this issue, and he's made the point that if you want to think about it very personally, no one who really loves their mother would want to end their mother's life. So if you think about this on that personal level and remove sort of the false emotiveness of this issue of sort of abstract philosophical questions about my body and about what I can do and what my will is able to force onto others or cause in my own life, and bring it back to a community context of love and of relationality with people in your life. So in the same way that people who are considering what we can call traditional suicide need love, need counseling, need witness in their life, need people to smile back at them, need people to remind them of who they are as somebody with basic human dignity, a universal human dignity that we all share. So too do people facing assisted suicide or considering euthanizing or engaging in even just ill treatment of a loved one facing any kind of condition. So the words are increasingly deceptive. End of life may not mean that somebody's actively dying. Terminal may not mean somebody's facing a true end-of-life disease. And so language, I'll wrap up here a bit because I want to take questions, but the language issues are so important. Three language issues I want to talk about. Quality of life is a phrase to avoid. Do not speak about somebody's quality of life, because quality of life changes. Sometimes day to day, sometimes hour to hour. So, instead talk about a person or a patient's condition. Because the quality of life is something that is going to be malleable, it's going to change, and the more that somebody's loved and encountered and respected, the more their quality of life improves. That's a very pernicious phrase that's constantly used to justify things like assisted suicide. Well, they have a poor quality of life, so we should help them do some terrible thing, without ever asking the question of why do they have a bad quality of life? Now, maybe it is purely medically, but human encounter is something that can truly change hearts and change lives, even for somebody who thinks that they can never get better again. The phrase suffering, how often do we hear that? In the same way that there are so many emotive words about the abortion issue, the euthanasia issue, the assisted suicide issue, we say this person is suffering with something. And the more that we want to politicize it, the more that we kind of amp that up. And we say, isn't this terrible? Instead, try experiencing. Terry Schiavo, for instance, had a brain injury, so she was cognitively and physically disabled as a result. She was not actively suffering on a day-to-day basis. She wasn't in pain. She had a disability. So she was experiencing something. She experienced a disability and then had to live with the consequences of that, but she wasn't actively suffering. And so that's a way that you can be manipulated into saying, well, if they're suffering, maybe it is end of life, maybe it is terminal, a phrase to avoid. And then finally, just the end-of-life issues in general. How often are end-of-life issues ultimately health issues or just life issues? So if we keep these things in mind and don't fall into the demeanor or the mode of kind of ceding the intellectual, verbal territory, emotional territory to those who would want to change our perceptions of what compassion is, from relationality, from love, from bravery, to facilitating terrible choices and terrible ways of treatment. And so these issues all relate to human dignity because they relate to what is care. Is care a physician helping to end life or helping to treat illness, helping a patient experience the best kind of life they can have? What is care? What is healing? What is dignity? These are the questions that we're facing when we deal with the assisted suicide issue and when we deal with the euthanasia issue. And so ultimately, I think the best response to all these things is a good kind of mode to be in life in general, which is that we have to be brave. We have to be brave with each other. Because if we're not brave in facing conditions either that we have personally or that those in our life might be facing, it's going to seem more logical to take terrible routes. But if we're brave and if we're with each other and witnessing to each other in our lives, a lot of these things that seem like they should be a default way of being in terms of political legislation or in terms of just sort of a permissiveness to say, well, who am I to say anything? Maybe that's just a personal choice. Falls away very quickly. And finally, on this issue, don't let it be a personal choice. Because in the same way that abortion can never be a personal choice, because you're dealing with a human life, these issues of assisted suicide and euthanasia are never merely personal because we're relational creatures. So it's not just about your will or your desire. It's about a being with others. And that's the core of any healthy society. And so if we allow it to be personalized, privatized, where they say this is an issue that should just be left to this person to decide and we shouldn't get involved. You notice we don't do that with any other social issue in this country because government's natural mode is to be concerned to some degree with public spirit, public virtue. This is why some states are commonwealths, explicitly to talk about cultivating virtue in the citizens. And so we don't want to privatize the issue because it's natural in the public square to figure out how to build a healthy and humane society. And that's what ties this all back to human dignity and the larger themes of this conference. So thank you very much. You want to take questions?
Okay, we have time for a few quick questions. So if anyone has a question, feel free to raise your hand and we'll come around to you.
This question is for Catherine. We're from Massachusetts, specifically Boston, and in Massachusetts there's a big push for physician-assisted suicide. I wanted to know what are some sort of counterpoints or things we can sort of speak to people who just make it as a dignity issue or an issue of people deciding how best they should manage their own treatments. How can we best answer these people that, they're very loud, and we'd like to know what we can do as young people to really counter all the arguments they're giving and sort of be articulate about that.
Well, first of all, this is an issue that affects everyone. It's not an issue that only relates to certain communities, certain ages. It can impact every single person in America, and it can impact everyone right now. So one of the key things that I think is important is building a strong coalition. Some of the people who are most impacted, but even though all of us are, but you build a coalition of medical professionals and hospice workers is important. Disability rights people, all of the different people who are perhaps most clearly implicated, but just start educating about how this impacts everyone. It increases the suicide rate generally. We're talking about elder abuse, about coercion. You look at the flaws in the laws, and we're seeing where the witnesses can be an heir and his neighbor, an heir and his cousin. I can go down the list of all the intrinsic problems with this. It really is at its core a human dignity issue. It's about protecting the profession, not about protecting the person, and we see that when we look at what exactly it does. It authorizes the medical profession to lie on the death certificate, to say that the cause of death wasn't the act, it wasn't the poison, it was the underlying illness, and I think that just illustrates clearly what the core issue is.
We have time for one more. Here you go. And this is a question for Tom.
Hi, I was just wondering what patients should do to protect themselves from being taken advantage of, since an advance directive can be used against them.
Yeah, great question. So advance directives are vulnerable to misinterpretation, and just the fact that you can never anticipate everything that's going to happen to you medically or to a loved one. The most important thing you can do that we talk about at the Terry Shriver Life and Hope Network for the people we assist is to have a heroic advocate in your life. Now that can mean, from a legal standpoint, that a baseline of having a good, durable power of attorney to empower that heroic advocate. But to that relationality issue I spoke about, to have somebody who understands what a human person is and who you are, and who is very explicitly willing to fight for you should something bad happen to you, either in youth or in old age. So there's no substitute for somebody who's willing to fight.
Awesome. How about a big round of applause for these two?